On July 3, 2023, the South African High Court handed down a landmark judgment. The court's considerations regarding the positive civic role of investigative journalism and its methods to combat corruption laid out a positive framework protective of press freedom. Despite the fact that 1996 Constitution protects press freedom, being an investigative journalist in South Africa is not an easy task.
It's a privilege and a curse. It's a privilege because we have a democracy, we have legal protection, but it's a curse because there's a lot wrong. The country is virtually broken.
I would say daunting because there are so few of us and so much work to be done.
I would say it's inspiring and necessary. And inspiring because I know firsthand the risks that journalists face. The work that investigative journalists do is sometimes what feels like it's the only thing holding the country together.
In February 2023, the AmaBhungane Centre for Investigative Journalism published 3 articles critical of the business activities of the Moti Group in Zimbabwe and South Africa. Some of the claims were based on information provided by an anonymous whistleblower. The Moti Group used legal actions, including obtaining an order requiring that the AmaBhungane return any digital documents obtained by an internal leak.
This was a case about source protection, and it was a case about the right to make use of leaks. It was also a slap case, in the sense that the protagonist who we were writing about used both the courts and, in fact, social media to launch a concerted campaign against us. There were quite significant personal attacks on my history and character, shall we say.
And simultaneously, he hired a PR firm to produce, quite slick videos that were constantly made available on the internet, attacking, like you said, Sam.
And then there was the sort of use of some of his supporters to also start attacking us on social media and broadly by issuing press statements criticizing the work that we were doing. And then the final prong was the legal prong. And that also sort of came about with a threat of potential criminal action against us, and then obviously the civil action that did get followed through.
AmaBhungane brought an urgent motion for reconsideration. Thus, the question before the High Court was posed whether it is intrinsically unlawful for journalists to receive, retain, and preserve leaked information and to publish it in the public interest.
We have legislation that gives effect to the right to access information, and we have a very strong judiciary that steps in when perhaps those laws aren't given effect or aren't implemented properly.
The legal framework is strong. The respect for that legal framework is diminishing, I think, from a number of quarters, both from government and from other players.
It was not certain what the court would decide. The court decision was clear. The court established a precedent highlighting the danger of private companies bringing extensive litigation against media outlets and stressed that the courts cannot tolerate abuse of process. The court also emphasized the importance of maintaining sources' confidentiality and that the rights to privacy can be limited when publication of private information is in the public interest.
We have the right to privacy as well as the right to freedom of expression. And this was a big test, potentially, of the balance between those two. And the judgment came down very clearly, and quite succinctly and unarguably on the right of the media to penetrate some of that veil in the public interest.
This decision is exceptional because it advances freedom of expression on multiple levels. Firstly, it identifies the litigation against AmaBhungane as an abuse of process and introduces criteria for understanding SLAPs. Additionally, it emphasizes safeguarding anonymous sources crucial to investigative journalism and highlights the significance of protecting whistleblowers. Finally, the departure from precedent regarding corporate confidentiality enhances press freedom, particularly in matters of public interest. What was really important about this judgment was that it was taking that strong jurisprudential tradition of protection of the media and applying it to the realities of a very online and technological world that we as journalists are operating in.
I think also there's an element of exceptionality in that it counted what was an exceptional attempt on his part to essentially criminalize leaks, to say that the leaking of information is criminal, or the use of the information from the leak is criminal, which is obviously a devastating notion for journalism everywhere in the world.
It was certainly a great relief when it happened, I think it does strengthen our hand. But I think the way in which it also confirmed the protection of whistleblowers and the right to protect their anonymity where appropriate. That's important for some of these struggles going forward.